Welcome to our webinar today on international disputes in the oil and gas sector. I'm David Anderson and I'm here presenting today with my colleague Claire Stockford. I'm a partner in the firm's commercial disputes team and my voice may be familiar to those of you who tuned into the webinar providing an oil and gas case law update on 12th October. If anyone missed that and would like to see it, you can find a link to it in the events section of our website. Claire is a partner in the firm's international disputes team with experience in both commercial and investor-state arbitration. We both have a particular interest in the energy sector. Some housekeeping to start. To minimize background noise, we've placed you all on mute. If you'd like to ask questions, please do so using the chat function. As we're trying to keep to time, we'll answer as many questions as we can at the end of the presentation rather than as we go along. We expect today's webinar to last around half an hour. We're going to talk through some of the considerations that apply to resolving disputes in an international context and look at some of the recent trends. As many participants will be aware, conducting business internationally adds some extra dimensions to negotiating dispute resolution clauses and dealing with disputes. The nature of the oil and gas industry today is that it is international. Contracting counterparties will often be from different countries and different legal cultures. The project may be located in a third country, foreign to both counterparties. Pipelines might cross several different jurisdictions. These circumstances add an extra layer of complexity to any element of a deal, but particularly dispute resolution. We all know that often dispute resolution clauses are a low priority in the deal-making negotiations. No one wants to focus on the project going wrong before it even gets started. That's understandable. But it really is worth taking the time to get these clauses right. Whatever you decide on the content of the clauses, it's essential to make sure that they are clear. Ambiguities have the potential to become an expensive and distracting sideshow, generating litigation about how or where the dispute resolution is to take place before a claim can even be started. This is true for all dispute resolution clauses, but particularly important in international deals, where an ambiguous clause could mean long drawn-out proceedings in an unfamiliar jurisdiction, perhaps in an unfamiliar language, with all of the expense and time that entails, just to determine where and how the dispute should be decided. You need a clear choice of governing law and a clear choice of body to hear the dispute. International deals tend towards using international arbitration as the means of dispute resolution. This is for very good reason. In many cases, it's undesirable for the foreign investor to end up in local courts, which may be thought to favor the local participant in the deal. When doing business in stable countries with a strong rule of law, opting for dispute resolution in the local courts might be acceptable. But in many international deals, the parties will agree to have their disputes resolved in a new third venue where neither is based. And that typically means using international arbitration. The Queen Mary survey in 2013 found that 56% of energy sector respondents preferred arbitration over other methods of dispute resolution. And the International Center for Energy Arbitration survey, published in 2015, found a similar level of support at 58%. Only 8% of respondents to the latter survey favored litigation. No doubt the international nature of the industry played a large part in that. If you do decide to opt for international arbitration, you will need to design your arbitration clause. The question will arise whether you use a set of arbitration institution rules, such as ICC or LTIA, or any one of the other alphabet soup of institutions on offer? Or will you opt for an ad hoc process without an institution administering the arbitration? Using an institution to administer an arbitration is the more usual path, but ad hoc arbitration processes can be appropriate, particularly for a major project in which it is likely that there will be a number of disputes. A good example of this is the Channel Tunnel project, where an ad hoc arbitration process was designed for resolving disputes related to what was a vast and complex engineering project. Whether you decide to use institutional or ad hoc arbitration, there are many other points to consider. For example, how many arbitrators will be appointed and what will the appointment process be? What language will the arbitration be in? This could have a major impact on costs. If, for example, there are a lot of documents which need to be translated and witnesses who need to be interpreted? Could you opt for a papers-only arbitration for disputes up to a certain value to keep costs down, or a single arbitrator, which is usually quicker and cheaper? Do you want to impose a time limit for the arbitration process? We've seen expedited arbitrations take place from request for arbitration to final hearing in 6 months. That sort of timescale is not the norm, but it can be done. The downside is that with such an expedited timescale, your arbitrator or expert of choice might not be available. But the upside is that you can get your dispute resolved quickly and move on with the project. One of the advantages that arbitration offers over litigation is that it is a flexible process that can be molded to the parties' needs. In the melee of contract negotiations, some of these non-standard options can often be forgotten. It's easy to insert one of the institution's standard clauses into the contract, and there's nothing wrong with doing this, but it is worthwhile thinking whether some of these additional options might be helpful to your circumstances. You will also need to choose substantive law that will be applied to the contract. Once more, it is essential that the choice of substantive law is clear, so that this point in itself does not become a dispute. English law is often chosen by the industry as it's seen as a well-established and trusted legal system, but it will not be the right choice in every case. Nor in the case of arbitration will it usually be the only body of law that applies to the dispute. Procedural matters, including key points such as challenges to arbitrators and awards, will be determined by the law applicable to the place where the arbitration is seated, and I'll talk more on that later. If no substantive law is selected by the parties, the law applicable to a dispute will be determined by the courts according to their own national criteria, or arbitrators applying private international law principles. This can be a vexed question. In almost all cases, it will be advisable for the parties to make an explicit choice of law at the deal stage, rather than to thrash the question out when the parties are already in dispute. Also consider where will the arbitration be seated. It's important to have a location in a New York Convention country as a seat to make enforcement of the award easier. On the screen at the moment is a list of countries that are not parties to the New York Convention. You can see that it is a pretty short list, and that most of the countries with which you'll be doing business do not feature on that list. Winning an arbitration can be a hollow victory if you don't get paid. That is, after all, the end goal, and some groundwork at the point when the dispute resolution mechanism is being agreed can give you the best chance of obtaining that outcome. Bear in mind that the arbitration may not actually take place at the chosen seat. Usually hearings can be located anywhere that the parties or arbitrators choose. However, it is important to take advice to be aware of any national quirks in this regard. For example, in the UAE, the local arbitration law has been interpreted by some to mean that UAE-seated awards not signed in the jurisdiction could be regarded as foreign rather than domestic awards with implications for enforcement. I've heard stories of international arbitrators flying in and convening award signing meetings in the airport and then flying straight back out just to make sure that their awards cannot be challenged on this basis. That obviously adds a cost to the process, so it's worthwhile taking advice on these issues at the outset to save time and costs later. You'll also need to consider whether to make your choice of jurisdiction exclusive. Exclusive jurisdiction would mean that a dispute can only be heard in the chosen venue, whether that be a court or arbitration tribunal. If a party commences proceedings other than where agreed, that forum will determine, according to its own rules and the rules of private international law, whether it can hear the dispute. Most jurisdictions around the world will accept an explicit choice of law by the parties and decline to hear the case if they are not the chosen jurisdiction. If you insert a non-exclusive jurisdiction clause in the contract, this maintains flexibility for the future, but could lead to a race to be the party to seize a favoured court first, with a risk of competing cases in different jurisdictions. All of the points raised in the past few minutes are very fact-dependent. There is no one-size-fits-all advice that can be given as to what route will be best. We're always happy to talk through what options might work best for you. I'm now going to hand over to Claire, who's going to talk about a couple of recent trends in international arbitration which might be of interest.
Good afternoon, everyone. The first thing I'm going to talk about is emergency arbitrators. A number of arbitration institutions have now introduced emergency arbitrator provisions, allowing parties to seek interim relief within the arbitration process, even before the tribunal has been constituted. This is typically used to seek injunctions or other urgent types of relief as an alternative to going to court for this sort of assistance. This may be useful if the matter is sensitive and the parties wish to enjoy the confidentiality that arbitration typically offers in instances where some sort of interim remedy is required. The emergency arbitrator provisions can be either opt-out or opt-in, depending on the institutional rules that you're using. So if you're using rules that contain an emergency arbitrator provisions, you'll need to consider at the deal stage whether you wish to opt in or out of them. Another trend is a focus on costs, efficiency and transparency. The proliferation of arbitration institutions means that there's a lot of competition between them at the moment. Each institution wants your business. One result of this increased competition is a focus on costs and efficiency as institutions seek to make themselves appealing to users. They are also making public more information about their cases. For example, the London Court of Arbitration, the LCIA, now publishes cost and duration data. This shows, for example, that the median duration of an LCIA arbitration from request for arbitration to final award is 16 months. The website also shows some analysis of arbitration costs compared to other institutions. The LCIA charges an hourly rate for the arbitrations it administers. Other institutions charge according to the value of the dispute. Therefore, which arbitration institution is most cost-effective for you may depend on whether the project is most likely to generate complex low-value disputes or relatively simple high-value ones. Respondents to the International Centre for Energy Arbitration survey that David mentioned earlier expressed a clear preference for hourly rates rather than ad valorem fees, perhaps reflecting the fact that there are often substantial sums in dispute in energy sector cases. Other institutions are also focusing on costs and efficiency. The latest version of the ICC rules requires the parties and arbitral tribunal to conduct proceedings in, quote, an expeditious and cost-effective manner, end quote. There can be cost sanctions if this principle is not adhered to. In addition, the ICC now ties an arbitrator's remuneration to the time taken to render an award. The ICC has also taken steps to increase transparency. It now publishes data on arbitrators, including names, nationality, whether the person sat as a chair or sole arbitrator, and whether they were appointed by the parties or by the ICC. Another trend is towards tiered or dispute resolution clauses or escalation clauses. These clauses typically provide for some form of non-binding dispute resolution process, typically a period of negotiation or perhaps mediation, before the parties can proceed to binding dispute resolution, usually in the form of arbitration or litigation. For example, the AIPN model, Joint Operating Agreement, provides a number of alternative methods that can be used cumulatively or independently, including notification, negotiation, mediation, expert determination, and arbitration. The default position is that parties will agree to final and binding arbitration rather than having the option of using the court process. In our experience within the oil and gas industry, there is a real drive to resolve matters through negotiation rather than formal dispute resolution. This is reflected in that many of the standard form oil and gas contracts, which now provide for parties to try to resolve disputes through a negotiation procedure before a formal court or other ADR method can be used. This is something that parties often want to have in the agreement because of the collaboration between the parties and the hope that in the spirit of the agreement, any disputes can be resolved by escalating matters up the chain of command. In the survey conducted by the International Centre for Energy Arbitration in 2015, 83% of respondents were in favour of this being a mandatory step. The object of these clauses is to resolve disputes more cheaply at an early stage, without resorting to full-blown arbitration or litigation, if at all possible. They can be effective if both parties participate in the early tier processes in good faith. However, in reality, this does not always happen. For example, in a dispute over payment, the non-paying party can use the negotiation or mediation phase to keep its counterparty out of the money for longer, and then make them go through litigation or arbitration to get an award or judgment they can enforce. These clauses can be useful, but should be used with some degree of caution. In reality, regardless of what the dispute resolution clause stipulates, there will usually be some attempt at discussing the issues informally and attempting to find a way through. The need to serve notices or involve specific personnel stipulated in the dispute resolution clause could actually stifle the natural negotiating process. If the parties are not inclined to find a resolution through negotiation, early tiers can just become a set of hoops to jump through before the parties get to a form of binding dispute resolution, doing nothing to progress matters. The operation of the escalation clauses should be carefully thought out. For example, is it appropriate to stipulate managing director to managing director discussions in all cases? Might it be better to use people closer to the contract or someone lower down the management hierarchy? If a low-value dispute emerges, might personnel be reluctant to invoke the process if someone very senior needs to be involved? The AIPN contract sidestepped this problem by suggesting that any negotiation be conducted by a senior executive, which is defined as any individual who has authority to negotiate the settlement of the dispute. It's going to be difficult to provide for every possible scenario, but it is worth thinking through quite carefully what sorts of disputes are most likely to arise out of your project, so that you can agree how they might best be dealt with. As with all dispute resolution mechanisms, a key point to bear in mind when designing an escalation clause is clarity. You need to make sure that each step of the process is clear and that all eventualities are provided for. For example, what will happen if one party refuses to engage in the process? How can you move on to the next steps to achieve resolution of the dispute? If one party is dragging out the non-binding stage of the process, how can the other party or parties move forward without wasting time? So far, we've focused primarily on litigation and arbitration as means of resolving disputes, but we have also mentioned some alternatives, and they should not be forgotten. They can be used on their own or as part of a suite of methods to resolve a dispute, such as in an escalation clause. Most methods of dispute resolution other than litigation and arbitration are non-binding, but can nonetheless be useful. We talked earlier about having some sort of principle-to-principle negotiation process as part of an escalation clause. Of course, you don't need to provide for it in your contract for such a negotiation to happen. Any dispute can be resolved through negotiation at any point. Mediation, which is a negotiation guided by a third party, can be a valuable tool in bringing the parties together. Even if the entire dispute is not resolved through the mediation process, the parties might find that mediation has significantly narrowed the issues between the parties or brought certain points to the fore so that a meaningful negotiation can take place. It's not uncommon for disputes to settle shortly after a mediation. It's worth bearing in mind that it's not necessary to choose a lawyer mediator. Whilst this might be right in some cases, in others, a technical or industry expert might be better suited to mediating between the parties. Mediation can be included as part of an escalation clause, or it can be agreed on an ad hoc basis after a dispute has arisen. If it's likely that the dispute will end up in the English courts, the parties will need to show that they have considered mediating their dispute, and if they have chosen not to mediate, will need to give reasons for that. Parties that dismiss mediation without good reason could find themselves penalised in costs if the case is heard before the English courts. Another alternative method of dispute resolution to consider is expert determination. This is quite commonly used in energy contracts and can be very effective when applied to the right kind of dispute. The parties might want to consider what sort of disputes could be referred to expert determination and make sure that these are clearly defined in their contract. Valuation issues and technical disputes tend to lend themselves well to this form of dispute resolution. If you are planning on using an expert determination clause, it's essential to make sure that the procedure is clearly set out, with each of the steps and relevant time periods set out for the parties. You should make sure that the clause provides for contingencies. What will happen if one party refuses to take part in the expert determination process? What will happen if the parties cannot agree on the appointment of an expert? An additional consideration in international projects is whether there is any place for, in place any investment protection through an international treaty. Regardless of the commercial dispute resolution provisions agreed, treaties might offer foreign investors additional protections. For those who are unfamiliar with this area, there are around 3,000 bilateral and multilateral investment treaties in existence today. The UK has signed up to more than 100 such treaties. One multilateral treaty that's of particular interest in the energy context is the Energy Charter Treaty. There are 52 signatories, including the UK, plus the EU and Euratom. These treaties are designed to encourage foreign investment by offering certain investment protections to foreign investors. The protections offered vary between agreements, but typically include that the foreign investor will be treated no less well than local investors by the host state, and that the treatment accorded by the state to the investment will be fair and equitable, and that there will be no expropriation without due compensation. These standards might be breached, for example, by the regulatory environment changing in a way that unfairly prejudices foreign investors. More frequently, we're seeing a number of indirect expropriation cases, where a foreign investor in a project gets pushed out by a number of small steps taken by the state. Typically in these cases, the contract will be re-tendered and will end up in the hands of a local player. A key requirement to bring such a case is some sort of government involvement, as the claim is made against the state. That might be in terms of a breach by a government counterparty to an exploration and production contract, or through government action or inaction. I don't want to go into too much detail about this type of dispute resolution, as it's frankly a webinar series in itself, but I really just wanted to make people aware that it might exist in addition to whatever form of dispute resolution has been agreed in the contract. It can be particularly helpful as an alternative to ending up in the local court. Investment treaties usually provide for arbitration at ICSID, the International Centre for the Settlement of Investment Disputes, which operates under the auspices of the World Bank. Typically, experienced public international lawyers are appointed as arbitrators, although others, such as economists, can also be appointed in these cases. As is usual for arbitration, there's no appeal from the award that is made, but there is an annulment process that exists as a check and balance, through which awards can be annulled on narrow grounds such as procedural irregularity. I don't think any seminar or webinar can be complete at the moment without the obligatory comments regarding the impact of Brexit. The good news for parties choosing to resolve their disputes through international arbitration is that the impact should be negligible. International arbitration operates outside the EU system and will continue to do so. Enforcement of arbitration awards takes place under the New York Convention, to which 156 countries across the world have signed up, with the exception of the list shown earlier by David, and that enforcement process will continue unchanged. The post-Brexit litigation landscape might be different. It will depend what deals are negotiated between the UK and the EU. Currently, jurisdiction between courts within the EU is governed by EU law. We don't yet know what provisions will be put in place once Brexit happens. I'll hand back now to David.
It's now time for questions, and questions can be submitted by typing in the chat box. While you're typing in your questions, if you have any, I'm going to mention that this webinar is part of our oil and gas series. Past webinars from the series can be found through our events page on our website. The next one in the series is on the 9th of November, and we'll be looking at the new regulatory regime for upstream oil and gas. You can book your place now through our website. I'll just look to see if we have any questions. I don't think that we do, so I'll now bring the webinar to a close and thank you all for attending. Thank you.